associated with the Monash European Youth Center for quite a number of years already. So it was so good last time that we had to re-invite you. And as you probably know, Stephen is a partner, of course, Chamber Westgard. He's the chair of the firm's Europe Focus Group, so there's definitely a European connection there. He's also an intellectual property lawyer with significant practice in the patent and trademark litigation areas, including protecting international brands. Of course, it's very much related to what we're going to talk about today. Stephen has acted for a wide range of clients, and if you visit the website, it's very clear how many clients. And you've had many connections as well with European institutions, including the European Commission, so you've given advice to the European Commission. You also have a specific connection with France, and so we have to say here that you've received a very important, I guess, appointment with, as a Chevalier of the Ordre du Mérite Agricole, so by decree of the French Republic. So that's definitely an honor. And I will stop talking here because I could go on and on and on, but actually the real speaker is Stephen, who is going to tell us how to lobby the Australian government, I suppose, in a way. So I think it's a very, very exciting time to be talking about this, because it's also, we've seen also some developments in the papers recently, just exactly on these issues. So welcome.
I should start by saying that if any of you have any questions, it's probably easier for each of you to interrupt me as I go, rather than waiting until the end. If I use legalese or speak too fast, just shut me up or ask me to repeat myself, so don't hesitate, please.
And there is a microphone here if you want. I don't think I should give it to you, Marine, maybe?
So I can...
So you can, yeah, okay. Whenever, so just have to switch it on. Thank you.
Parallel importation is another word for talking about what are called grey goods. Grey goods are genuine products manufactured by the original brand owner, which are imported from one country to another, but not through the usual authorised channels. By way of example, if we take products made in, let's pick a country purely at random, Paris, France, and let's take products that may be made, perfume products that may be made by Christian Dior, for example. There will be authorised channels from Paris into, for example, the USA, for example, to Australia. And those products are sold either by Christian Dior to its licensees or to its distributors, in some cases to its subsidiaries. And they're the normal authorised channels. How parallel importation occurs is that some person without any authority or any connection with, in our case, Christian Dior, purchases the products, in my example, on the open market in New York. Again, we're talking about genuine, non-counterfeit products, and imports them into Australia for resale. So with the Australian dollar being so strong, it's very easy for Australians to find products offshore that are selling at quite good prices, usually end of season clearances from various countries, and import those products into Australia to sell them in competition with the authorised distributor or the local licensee or the local subsidiary. And it's called parallel importation because there are parallel lines of importation of the products into Australia, as that map tries to make clear. Two separate lines, one authorised line, one unauthorised line. And for decades, and certainly as long as I've been practicing law, and I'm not prepared to admit that's 32 years, but for at least those 3 decades, clients have tried to stop parallel importation, probably as long as it's gone on. If the products are genuine, if the products are made by the authorised manufacturer, the person who owns the brand, it's not easy to stop the products. Because if you're buying Coca-Cola, well, why can't you buy genuine Coca-Cola and bring them into bottles and bring them into Australia? Those of us who are lucky enough to travel, if we go overseas, buy clothing, for example, or personal goods for personal use, you bring them back into Australia, you won't think twice about it. And again, if they're not counterfeit, there's nothing wrong. Why should there be something wrong if instead of buying one pair of jeans, you buy 200 pairs of jeans and resell them at the marketplace? So, the question has been posed, why, of course, do these local distributors or the local licensees or the local subsidiaries, why do they want to stop parallel importation? What is it that is wrong with parallel importation? And there's a number of things. The first is that the local distributors generally will make a significant investment in the brands. They'll do advertising, they'll do promotion, they will set up distribution channels around the country. Depending on what the product is, they may set up warehouses of spare parts, they'll have trained staff, and so forth. And as a result, they have a significant investment that they want to protect. They will be telling the public about the benefits of these products that they're selling, yet what happens is that the parallel importer is putting no money by way of investment into the brands, they're simply buying the products on the open market. So the authorised distributors or licensees want to recoup their investments without having to compete against someone who's made no investment in the brand. And one can understand how that desire to have a monopoly in a brand might, to economists, sound distasteful. But in addition, think about the other matters that are up on the screen. If you are an exclusive distributor of a product in Australia, usually, in order to become the exclusive distributor, you have to promise to sell a minimum number of products. Someone won't give their entire exclusivity to you in Australia in the hope that you might sell some products, because if they can't sell to someone else, they put all their eggs in your basket. So it's quite normal with an exclusive distribution agreement to promise you will sell a minimum number of products each year. And if you don't sell them, well, that's up to you, as long as you make the payments on them, the royalties or whatever it might be, or buy them, and you just have to try to sell them whenever you can. So if you're now competing against an unexpected and an unauthorised parallel importer, you've got a problem. Often you cannot achieve your minimum required sales. Equally importantly, the brands are often sold by parallel importers wherever they can sell it. So you may have brands that have particular market niches that are put into retailers or wholesalers or market channels that the brand owner wouldn't choose. For example, products that require levels of service, levels of product knowledge, maybe put into general hardware stores where the local vendors aren't trained. Or luxury goods might be sold through down-market supermarkets. Again, what you're losing is control of your brand, losing the ability to make sure that your brand is marketed the right way, advertised the right way, serviced the right way, and so forth. And there are a number of occasions where you also have consumers exposed to damage or injury or risks. So what are the downsides for consumers from parallel importation? I'll tell you why it was brought in half a moment, but the downsides for parallel importation are generally as follows. The first is that, again, let me stress, these are huge generalisations. I cannot say that no parallel importer provides a warranty. There are parallel importers who warrant products, there's no question. But generally, the parallel importer does not give a warranty for the products. Normally, if you go back to the parallel importer and say, hey, I bought this widget or gadget from you last week, last month, and it malfunctioned or it's broken or whatever, they will direct you back to the authorised distributor, to the authorised licensee, who, having no obligation to you because they've never sold you the product, is in a quandary. What do you do as the genuine distributor of these products when someone comes back with a broken product? You can say, go away, or use other words, I'm not going to look after you because I didn't bring this in. And what are you doing? You're damaging your brand, because the consumer doesn't really recognise these subtleties between exclusive channels and parallel importation and so forth. Or you can say to the consumer, yes, we will look after the brand for you. We didn't bring it in, but we're great guys and we'll service your product. That's fine, but it comes with a cost. And so what we're finding is that where there's no warranty support for the parallel importer, number one, the consumer may get left out in the cold, especially if the authorised distributor decides to take the view, no, I'm not going to honour warranties on products that I didn't import. Or two, you may not be able to get all the warranty that you're asking for. There's also a risk of purchasing counterfeit products. It's very, very common that parallel importers bring in, whether deliberately or not, counterfeit products. We've had a case recently where there were several 100,000 bottles of particular alcohol product that were inspected by customs, and probably, I think it's numbers, 2/3 of the products were genuine, 1/3 were counterfeit. So every 6-pack of bottles of this particular alcohol, 2 bottles were counterfeit. And whether or not the powder importer knew that, we can't prove. Of course, they deny it. The other thing, of course, is that the powder importers generally are not experts in a particular brand or products they're bringing in. They're opportunists. Nothing wrong with that. It's a free market economy. I'm not being critical at all. They don't have the product knowledge to determine whether what they're buying is genuine or not. And they buy wherever they can at the cheapest prices. And you commonly will get products that are offloaded on them without their knowledge being counterfeit. So it's a really serious issue. Another problem is that the powder importers are often sold out of date stock, or stock that's reached its use-by date, or stock that's been mishandled. Again, food products that have been stored out of refrigerated containers, food products that are stored on wharves, again, not in cool areas. You don't know that. You won't know it until you open a product and eat it. So there are health risks associated with powder importation of genuine products. And of course, commonly with products that are not fast-moving consumer goods, but electronic products and the like, you'll find powder importers almost never hold spare parts, almost never have the technical knowledge or skills to repair the products, let alone to give advice about how to look after a product if there's a problem with it. What did we, the lawyers, do to assist brand owners who come and complain to us, or distributors who come and complain to us about powder importation? How do we try to stop the powder importation? Well, buying a product is legal. It's presumed we're not talking about counterfeits. We would try to use provisions of the Trademarks Act or the Copyright Act to, and ways I'll describe in a few moments, to stop the powder importation. However, and I'll go into all this in more detail in a few moments, in the 1990s, the then federal government formed a policy to specifically allow powder importation. It was a policy not just to amend the Trademarks Act because of other issues, but to amend the Trademarks Act, to amend the Copyright Act, to allow powder importation. Why? Because in the early 1990s, the Prices Surveillance Authority, which no longer exists, had presented a paper written by its chairman, Professor Alan Fells, who subsequently became the chairman of the ACCC, presented a paper on powder importation. And Professor Fells, in his infinite wisdom, said, I recommend you allow powder importation because it will drive the price of products down. It will remove artificial barriers to free trade, and it will allow anyone to bring products into Australia. And it means that the authorised distributors cannot charge monopoly rents. It means they have to be economically efficient, or else they'll go out of business, and you'll still be able to buy the products because if there's a demand, then the powder importers will bring the products in. So this is all driven by pricing. We'll get the cheapest products for the consumers. But that report had no empirical studies carried out to support it. Economic analysis was clear and correct on pricing. I think if you find a product, a genuine product being sold by a powder importer, generally it is less expensive. No problems. Alan Fells was completely correct. But he didn't do the fulsome research, which I'm going to take you to in a few moments. Sorry, not take you to the research, take you to some of the issues in a few moments. And he didn't make inquiries about trademark owners, brand owners, what effect would it have on them? What effect would powder importation have on licensees and distributors or subsidiaries? What effect would it have on consumers? So it may be okay to open up the barriers and drive the prices down, but it's not that the market doesn't operate just on the question of price. There's service, there's backup, support, warranties and the like. And Professor Fells' analysis didn't touch that at all. And if it did, the market is not reacting the way that he thought it would. But I can say the report didn't deal with those things. So let's just go back a step and to put things into context about what one can do or should do, let's just talk about legal means that were used and that's still open to stop powder importation. Again, remember, take the example of a pair of jeans or a bottle of perfume, genuine product, sold overseas. Why should you be prevented from bringing the product in? I've given you some of the reasons in the past. For bringing it in for personal use, law won't stop that. But for resale, well, it's a different issue. So let me go back and tell you about what manufacturers, distributors, licensees, resellers, genuine resellers used to do. The first is that we used, as I said before, the Trademarks Act. There were 2 or 3 options I'll run through. We used the Copyright Act, and we used what was then called the Trade Practices Act, or now the Australian Consumer Law, which prohibits misleading or deceptive conduct. And the cases ran this way. I'm not going to take you to chapter and verse of justice this and judge that. It's all boring. It makes me go to sleep and I'm a lawyer. But one of the first cases was run by Atari, and it sued Dick Smith for bringing in genuine Atari products and selling them as a powerful importer. That case was run what the lawyers call a Friday night special. You go into court last thing Friday night, about 4 o'clock on Friday night, you ask for a judge to be available on an urgent matter on Friday night. You turn up before the court without the other side being there, so Dick Smith didn't know he was being sued, and he dropped before the judge a pile of papers this big and say, Your Honour, we want an urgent injunction, it's terribly critical, it's all on those papers. And it used to happen that judges would say, well, hold on a moment, I'm not sure about time to read all this, it's Friday night, the pubs are just opening. What are you after, Mr. Lyons or Mr. Merkel, whatever it might be? And this is quite seriously what used to happen. And the judges would pay a lot of attention to what some of these leading barristers would say, quite rightly. And the Dick Smith and Atari case was run on the basis that the barrister said to the judge at 4:30, well, Your Honour, I can take you to the 500 pages, but the bottom line is this. The Trademarks Act says the trademark proprietor has the rights to exclusive use of his trademark in trade or commerce. Well, we didn't put these parallel products onto the market, Your Honour. Someone else is making use of these products. I want an immediate temporary injunction. It's not a permanent injunction that lasts forever. It's just an injunction on a temporary basis until the case reaches trial. And the legal term is interlocutory injunction. And the judge, God bless him at the time, said, I think that's sufficient argument. It's now 4:45, well, I make the injunction. So that Friday night special got through. It wasn't a judgment that forms legal precedent as binding. It was, well, for the purpose of this injunction, I'm prepared to agree that Dick Smith breached the exclusive rights of use of the trademark owner. And so that was one of the earliest cases, recent earliest cases, where parallel importation was successfully stopped with the Trademarks Act. Other ways it could be done, because the court started getting a little bit more careful, and they were saying, well, hold on a second, that was actually a real genuine product. How do you say that you've got the right to stop that? So other attempts, or other successful attempts, have been that you could actually register the local distributor, the local importer, authorised importer, as what was called a registered user. And they had specific rights to bring in genuine products. And the Delphic wholesalers was the authorised user of trademarks for particular bottles of olive oil, and a company called Elco, power to import the products, and Delphic went to court and said, hey, Elco's misleading the public. They're saying that they are an authorised user, but they're not. Well, Delphic succeeded, but it's legalese. It's nothing more than a legal smokescreen. The courts, by the mid-80s, were starting to see through this, because how can you claim there's any true deception of consumers? Consumers don't care who's authorised, who's not. They want to know what's in that bottle. Is it genuine olive oil, maybe the genuine proprietor? If so, the trademark's telling me exactly that. So the trademark judges were getting a little bit sceptical about some of these events. But then there was another case relating to Fender guitars. In that particular case, Fender Australia had got permission from Fender Guitars overseas to register the Fender guitar trademark in Australia, because it carried out quality control and it had the guitars tested and I don't know if it's restrung or whatever, but it had real input into not the bottom line quality of the product, but into the to surveilling the products as imported to make sure they were adequately strung, to make sure they weren't out of tune and so forth when they were sold to Australian consumers. And they said, this is my trademark. The person who's brought these in from overseas, the power importer, isn't bringing products that have come through my supervision. I own the trademark. These aren't my products. It's a trademark infringement. And again, the court was happy to say, that's correct. You, Fender Australia, own that trademark. And this tactic, by the way, as I'll explain in a few minutes, is still being used today, where the local Australian importer or distributor or subsidiary becomes the trademark owner. Anyway, Fender managed to stop the importer of genuine guitars. But as I said a few minutes ago, the late 1980s, the courts are saying, look, you can use whatever silver-tongued words you want. The bottom line is that this product's got a trademark on it. The trademark was put on it by the genuine proprietor. It's its product. It's not a counterfeit. People aren't misled. They're not deceived. They only want to buy the damn product. Stop telling us this is trademark infringement. Now, as a lawyer, I can dress that up in a few thousand words for you. That's the bottom line of what the courts were saying. Something called the exhaustion of rights principle was being used. You've exhausted your rights to control the product. You put it on the market. Once it's on the market, the open seas of commerce, you can't control it, said the courts. So by the late 1980s, we couldn't use trademark law to stop genuine products from coming into Australia. So we changed our site, we as in the lawyers, to try to help the brand owners. We said, well, in case one of my partners relating to Bailey's, we sued the importer, Boccaccio, of this product, and I did the same for Weber Barbecues against a then retailer who was bringing in genuine Weber Barbecues. But the barbecues case is more, wasn't decided by a court, but it was exactly the same principle as Bailey's. What we said to the importer was, look, you can bring in the barbecues, they're genuine, made by Weber, that's not a problem. But we control the copyright. Now, the way the copyright law is written, you actually can carve up the globe into markets by country. Most countries, in fact I won't talk about international law, let's talk about Australia only because that's all I'm qualified to talk about. The Australian law enables a copyright owner to stop genuine copyright works from coming into Australia. It's peculiarity of the way the law is written to help artists, to help authors, to help painters and so forth. And at the moment, back in the 80s, you could prevent genuine products coming into Australia even if they were put on the market with your authority. So what we said for acting for Weber, or what we said acting for Bailey's, was, look, you can bring in the liqueur, or in our case, in the barbecues case, you can bring in the barbecues, it's not a problem. But you can't use the box because it's got our trademark, so we've got our copyright drawings and paintings and photographs on the outside, I should say. You can't use pleasure. You can't use the warranty manuals because we've written those, that's copyright. You can't use the guidebooks because we've written those that are copyrighted in them as well. Nor the instruction manuals. Bring the barbecue, go for it, but no boxes, no warranty codes, no manuals, no guidebooks, nothing. Well, you can't do it, of course. You have to make your own packaging, you've got to ship them yourself. Ultimately, as was the case in most of these situations, the pound importer threw up his hands and said, it's too hard, too difficult, I can't get around this copyright ban. As a result of the Bailey's case, so not my case didn't get to trial, thank God, the other side threw their hands up, but as a result of the Bailey's case, there was an organisation of, I think, I'm not sure it was DSICA, but Distilled Spirits Council of Australia, but one of the spirits or liquor importer councils went to the Australian Copyright Law Reform Commission and said, this is outrageous. It's Bailey's, it's genuine Bailey's. And we can't bring the product in because it's a damn label. This is ridiculous. Copyright law section, I don't know what, mad. They put a submission into the Australian Copyright Law Reform Commission, which made a submission, which took this point up and took it to government, and the government said, okay, we accept the submissions by the Australian Copyright Law Reform Commission. We're going to stop you, copyright owners, from enforcing your copyright, where your copyright is effectively for an accessory. It's not for the liquor itself, it's not for the barbecue itself, but it's for the labels, it's for the warranty manuals, it's for the stickers, it's for things that aren't the products themselves. So ultimately, the accessories, you can't prevent the importation of accessories to a principal product. So suddenly we couldn't use trademark law, we can't use copyright law, we've got a major problem. There were still, and there are still avenues, I'm using some avenues right now in a litigation matter running for a genuine producer and their Australian licensee to stop parallel importation, or to try to stop, or to impede parallel importation. It's difficult. Remember, government policy is we want to encourage parallel importation because it reduces prices. So there are a number of things you can do. The first is, if the product that comes into Australia is different from the product that's brought in by the authorised distributor, you've got an argument that consumers are misled or deceived. There was a case in there's Colgate, toothpaste put on the market by Colgate in South America, imported into England, but But the formula for the South American Colgate was different than the formula for the English Colgate. Because of different hardnesses or softnesses of the water in different countries, and as a result, the English consumers were not getting what they expected when they bought a Colgate. Equally, look at the wine industry. You may think, well, fast-moving consumer goods, this can't happen too often. There are vats, there are blends made specifically for particular markets. I think I'm right that the American market likes its wines are sweeter than some other markets. So the particular batches of wine, vats made specifically for the American market. If we import it into Australia, the same trademark on it, you'll find there's consumer deception. Equally going back for a second, talk about different construction and voltage. There are cases where people will buy, or used to buy, electronic goods with 110 watts or 110 volt products, electronic products, and they would fit their own converters to the product and bring them into Australia. To which our answer was, well, that's not the product that we sold. You've tampered with our product, it's not a genuine product, you can't do that, and those cases would succeed. Another thing that's done at the moment still is a case relating to Monsanto tyres. It arranged with the owner of the trademark whose products it was importing to assign to the Australian distributor the trademarks owned by the foreign manufacturer. And I'll tell you, let me bore you for a couple more minutes with the science, but without the science it's a bit hard to understand this. The way the Trademarks Act was amended in 1995, the government said we want to make sure that power importers can't be stopped. So what we do is we put a section in the Act that says a defence to infringement of a trademark is if the products had the trademark applied by the trademark owner. In other words, if they're genuine products, you can't be sued for infringement. So you may, if you buy a genuine product overseas, the trademark's applied by the owner of the trademark, end of story, the Trademarks Act cannot be used. What was done here was the distributor said, well, I own the trademark, these products that the importer brought in, they didn't have the trademark applied to them by me as the owner. Now, what happened in that case was the importer said, this is all a sham. The trademark owner has got the right to call for the trademarks back, the original owner, when the distributor loses a distribution agreement. So it's all a sham. The court said, I'm sorry, there's a genuine assignment. The distributor is currently the owner, and you didn't acquire these products in the first instance as a trademark. So that hold this thought, the Montana Tyres thought, because it becomes relevant later on. A lot of lawyers at the time, well, me included, published articles that said we think the decision is wrong from a policy perspective. I must say that I spent my time fighting power importation. I love to be able to use that, but we think that there's some flaws in the legal reasoning. And we tell our clients, you can do that. You can assign from the manufacturer to the Australian distributor or licensee, but we think that at some point a court will find against you. So it's not flawless, let me assure you. But this case becomes relevant to what I'll say about lobbying in a few minutes. Another possibility is to form a joint venture in Australia between the trademark owner, Australian distributor or licensee, assign the trademarks to that joint venture on the same basis that the trademark wouldn't be applied by the joint venture overseas. The Copyright Act, dead in the water. You can't use the Copyright Act at the moment for power imports that don't bear artistic works, which I'll touch on in half a moment. But we have been using for many years what was called the Trade Practices Act 1974, which is now the Australian Consumer Law. Because that legislation prohibits misleading or deceptive conduct, or making of false or misleading statements in trade or commerce. So what we said, and what we are saying in the cases running at the moment, are to the effect that the power importation actually constitutes, or the way in which the products are offered for sale of the power importer, include the making of a number of false representations. And as we're running this particular allegation at the moment, the sort of misrepresentations that might be made, and it's all totally factually dependent, of course, is that the power importer might represent by implication or otherwise that there are permitted or authorised dealer. The classic way that happened in the perfume industry was the particular Paolo importer stole our client's copyright, which we stopped them from doing, put a big sign on their premises with the name of a particular brand and the particular well-known advertisement that its client used to promote its brand. So the impression you got was, oh, well, this is another distributor of this particular brand of perfume. We stopped the copyright infringement, but we couldn't stop the sale of the perfume. We stopped them by saying it's misleading conduct. We stopped them by saying it is misleading and deceptive conduct. But all that happened was the person took down that signage and continued to sell the Paolo imported products. So there are only limited things you can do with misleading or deceptive conduct type of claim. There may be a representation that this person, as a dealer, holds stock, holds spare parts, holds or has a stock of knowledge about how to sell the product or service the product, or that the product comes with a warranty. You buy from a retailer, you expect it to be warranted by that retailer or reseller, and quite commonly the resellers or retailers who are Paolo importing will run wild, can't look after it, go back to the authorised distributor, they'll tell you. So we say that's misleading conduct. Equally, there may be other types of misrepresentations of those on the board. It's all factually dependent. You can't say this is what the false representation is in every case, because it depends on the conduct of the Paolo importer. But as I said before, the issue with misleading and deceptive conduct is it doesn't stop the actual conduct of Paolo importation. It stops the way in which the retailer or the wholesaler is trading the representations they make. The selling is still legal. So misrepresentations are sometimes difficult to overcome, but once they overcome them, the sales are still permissible. One step that some retailers are taking who are Paolo importing is they'll put disclaimers on products. They'll put signage up in stores saying these are Paolo imported products. These are genuine. They don't come with a manufacturer's warranty, but they're warranted by us. Well, provided the statements are true and accurate, there's not much you can do about that. The Paolo importer gets away with it. So probably the last method that is currently being tried, or the last mainstream method, is for the foreign manufacturer, the brand owner, to put contractual restraints on the distributors overseas and say to them, you may only sell this product in your country, be it the EU, or China or South America, to someone who is a consumer. You can't sell them to someone in another country. You can't sell them to someone who you know or suspect will export them from that country. So you try to territorially limit the reselling to that particular country. So it's a contractual restraint. These are hard to enforce because when you find products on the market in Australia by a Paolo importer, they won't tell you who they bought the product from. So how do you know which particular country sold the products? Sometimes there are the code numbers, the batch numbers that can identify the source of the products, but Paolo importers cut those off or change them. And I've run a couple of cases where we've said, unfortunately the case got settled, but we said the cutting off of the code was itself conduct that tampered with the product. It stops us, the genuine importer, from carrying out a recall, stops us from tracing the product if there's a problem with the product, so you tamper with the product and you can't sell that product because that product is not the genuine product the trademark owner sold. It's a different product because you've taken away a crucial element of the product. The issue with the contractual restraints is that, let me go back one step, I'm sorry, arguably, if someone has bought the product from Australia from overseas, I'll start again, forget the arguable bit. If you buy a product from someone overseas, you don't know whether they've got the right to resell or not. You've no reason to suspect they can't resell. What some of the courts are saying is, yeah, the person overseas who may have broken their contract with the manufacturer could get sued with the manufacturer. That's fine, contractual breach, not a problem. Sue them in Canada, America, wherever it might be. But that doesn't mean you don't take title to the product. You can't half sell a product. You can't sell a product, this is only for use in America. And if you sell outside America, I have the right as the owner of the trademark to take the product back. You wouldn't be buying products, for God's sake. It'd be crazy. I'm going to buy this pair of jeans, but if I take it outside of Canada or I bought it, they can rip them off me. It's not going to happen. So the courts are saying, no. You do take full title if you purchase a Bible, even for resale. But the person who breached their contract with the manufacturer may have a contractual claim against them. So again, these are all weapons that one tried. None of them is a silver bullet. Let me assure you that there are problems with each of these. So the question becomes, what can one do? Just before I move on to it, let me just say that the Australian position is very different from the European Union positioning. Again, I'm not a European lawyer, not authorised to practice in Europe, but in a couple of short sentences, it's very clear that within Europe there can be no barriers to free trade. You cannot stop someone who buys a product in Italy from selling it to Belgium or London or England or any other countries in the EC. So within the EC, barriers to trade are absolutely forbidden. But the border to the whole EC, sorry, I keep saying EC, EU, the borders to the EU are very different. There are a lot of bases on which the brand owners in the EU can stop powder imports coming into the EU. And in America it's very similar. There's no specific law like there is in Australia in the US. And there are a lot of cases where US distributors or licensees or brand owners have stopped powder importation. So Australia is very much out of step. I'm about to talk in a moment about where we go, what could be done to change the laws, because I have clients who come to me daily. I had an email that came in at 12:30 today from an international client saying, I've got a problem with my products being sold in Australia. Do you know anything about powder importation laws? I know a little bit, I said to him. This really happens on, it's not a daily, but a weekly basis. Before I go any further,